Hi, everyone. My name's Bob Tarantino. I'm in the Toronto office of Dentons. I'm an entertainment lawyer, which means I'm like just barely a lawyer, as my colleagues will happily tell you. Roman and I are going to spend the next 45 minutes with you talking about intellectual property. We are cognizant of the fact that we are like the only thing between you and lunch. So we are going to try and make this as brisk and as compelling as possible, with the caveat that we're sort of limited by the subject matter. It's intellectual property. We're lawyers. We're not magicians. We'll do our best to come along on this journey with us. I will turn it over to Roman to introduce himself and to get us started.
Thank you, Bob. My name is Roman Tsibulevskiy. I'm a US registered patent attorney. My background is computer science. I hold 10, 15 patents in my name, many in software. And I'm here to talk about AI with Bob. So I guess let's begin. Just to level set, how many of you have meaningful experience dealing with patents and copyrights? If you can raise your hand. Okay, so the audience is IP savvy. So just to make sure for those who didn't raise their hand, because we're before lunch, we figured we're going to use a Coke bottle as a way to explain the general concepts of IP. You can have one object, one product, one service, one good, protected by many forms of intellectual property. So in this example, we have like caps protected by patents, and the design of the bottle protected by design rights. You know, the packaging is copyrights, trademarks, and the secret sauce is obviously in the makeup of the Coca-Cola formula. So we've been talking about AI for the last several sessions, but what really is AI, right? So on the technical level, it usually falls into two buckets. One bucket is called machine learning, one bucket is called deep learning. Machine learning is typically, the way I think of it is generally as like baby AI, and the way I think of deep learning is sort of like the real AI that most people think about. And machine learning is the most common example that it probably is on everybody's phone are smart replies on Google Messages or templated responses on Gmail, things like that. So basically the idea is that you make the machine learn something from examples without programming the machine to do something like that. In contrast, there's also what's called deep learning. That's what everyone has been talking about generally, and that's commonly known as ChatGPT, Claude. These are the general models. Those use neural networks that mimic human brain in the computing architecture to train lots and lots of data. Generally, they're done on these giant data centers with lots of machines and servers, but there are a couple of exceptions. So since we're before lunch, the way I wanted to explain AI is to analyze it to a cooking recipe. Just like in cooking, you always have tools like pots, pans, knives. You always have ingredients like fruits and vegetables and flour and oil. And then you have the recipes, right? You take your oil, you pour it into a pot. So the same analogy is applicable to AI. So generally what that involves is every AI, whether it's machine learning, deep learning, is going to have some kind of a hardware infrastructure, a data center, some kind of a thing you could drop on your foot, something you can touch and feel. Then there's always going to be some kind of a software architecture. Those are going to be like databases, engines, and programs, APIs, things like that. And the same algorithm that's applied in the same recipe that we use in cooking is literally applicable to AI. You are using the same ingredients, the things you could drop on your foot. You're using the same software libraries, the databases, and the whatnot to perform a set of actions, to perform a set of steps to accomplish some kind of a machine-based result. And once we have that general framework in place, I took some screenshots and I prepared these from WIPO, which is World Intellectual Property Organization 2024 Gen AI study. As you could see, a lot of this innovation, where it takes place, is if you look at the left screenshot, you could see China is the big gorilla here. And then there's a couple of countries to the right, US, Korea, Japan, Israel, France, and then Canada, and then the rest of the world. And then you could see on the right as to where that breaks down into. As you could see, the three bolded entries on the list They are universities. They're not even companies. So something that's going to be discussed later by Joel in this panel is contracting. That's something that these universities do, is they utilize their IP through tech transfer offices to monetize what they develop. And then if you segment this data further, you could see the technology and the technical domain where it's going. As you could see on the chart on the left, you could see a lot of innovation is in image and video. And that's what's generally going to be in deep learning. That's going to be things like convolutional neural networks. And you could see on the right side, you could see the industries where the innovation goes. As you could see, for example, text goes into software, goes to document management, telecommunications, everywhere. My understanding from looking at the list of this audience, a lot of the subject matter that you probably are hearing about, you're learning about, is going to be in that area. It's going to be either image or video, or it's going to be text, like natural language processing. And you could see on the right, you could see in the charts in terms of filed patent applications, you could see these are the chart, the heavier blue indicates the last 5 years of patent filings, but the lighter blue indicates the last 3 years of patent filings. And that's generally when ChatGPT came out in November of 2022. And you could see in many categories, it's around 50% of filings have happened since ChatGPT came out, as that would being the revolutionary technology that enables a lot of new innovation to take place. So let's zoom in further on the common patent issues that I think a lot of you are facing. So these are the three common themes. First theme is, do I patent? Do I keep my technology as a trade secret, right? Just because I have a hammer, not everything needs to be a nail. I want to be smart about where I spend the money, what I think about in terms of disclosure. Second issue that I think is common is selecting technology to patent. You know, when in-house counsel, when inventors come to them, there's so much techno speak, they don't even know what's going on, and and the idea is that, how do I filter this information down? What factors do I use? And the third theme is minimizing patent infringement claims, which I've seen last year. It started maybe 2 years ago in terms of open source, and we'll dive into that. So the first theme was, do I patent? Do I keep something as a trade secret? So there's obviously many factors involved, the duration, detection of infringement, the disclosure requirements, the enforcement mechanism, the technical scope. In my personal opinion, obviously there's many reasons to file for patent protection, but you want to think about, uncommon, for everyday, people facing these issues. I think the most important one is the first one, infringement detection. So the idea generally is that if my AI invention is solely internal, it's going to be kept within the company. No one outside the employees will see it, unless there's investors banging down your door and saying, I want to see patents. Usually there's no reason to file patent in an application. Obviously there are exceptions, but generally speaking, if something is going to be completely internal, it should probably stay internal as a trade secret. Now, the next issue is, well, let's say I want a patent. Well, what do I patent? Now, so again, these are some of the factors that we can mention and we can discuss. So for example, technical character of the invention, eligibility, which has become a massive plague for worldwide patent offices everywhere in the world. Commercial lifespan, the obviousness or inventive step, and disclosure feasibility. So here, to me, the most important is probably going to be something between commercial lifespan and subject matter eligibility. Since 2014, there was a case in the United States that dealt with patent eligibility in an Australian company called Alice. That exploded and broke the barriers everywhere in the world as to, well, how much descriptive does something have to be patent eligible? And now, the same test has been applicable, in my experience, in Canada. They're basically using the same similar factors as the United States. And the way to think about it is, in my personal experience, is to think about, is it technical? Is the invention actually improving functionality of a computer? Not improving business, not improving some kind of a financial trading algorithm, but is it actually making computers run faster? Are you using less memory? Are you using less bandwidth, making more network efficiency or topology? Is it better? If it is, it's generally going to be eligible. And that's something to think about in terms of when you're selecting these things. Obviously, if technology is going to go, it's going to be obsolete in a couple of years, whether the investment is worth it, you should think about it, consider that. But generally, these are the main things to consider as to selecting as to what to patent. The next thing I want to talk about I think is going to be the most interesting. It's going to be how to minimize patent infringement claims. So typically speaking, these are the factors you want to consider, like consider filing your own publications, defensive publications, like IBM is a big company that does it. They use IBM.com. They use also IP.com. You should do whatever appropriate, do patent landscape searches, consider licensing agreements. But the last two are the most interesting. Community alliances and minimizing public disclosure. What do I mean by that? So roughly in November of 2023, Intellectual Ventures filed a bunch of lawsuits against a bunch of banks. The famous one was the JP Morgan. They also sued some insurance companies and other financial institutions. A lot of the stuff dealt with basically the underlying technology of AI, things like Kubernetes, Kafka. These are all open source technologies. But they were very, very clever in what they did. They mapped their patents to the open source technology that underlies a lot of AI stuff. Now, which is basically the standard that most banks, insurance companies, and financial institutions use. But what they did is they needed to find a tie between the standard and this particular bank. So what did they do? They started to look at job postings, social media, SlideShare, YouTube, with the ability especially to get summarization of YouTube videos. They started to say, well, JP Morgan Chase, you mentioned in your job postings that you're looking for engineers who are experienced in Kafka. Our patents map Kafka, therefore you probably infringe. And they started going job posting by job posting, LinkedIn by LinkedIn, SlideShare by YouTube videos, and they flooded the entire financial industry with these letters of accusations. I would bet there are people in this audience who have probably heard of this internally. So why is this important? This is important because if you're utilizing AI, your engineers are probably talking about a lot of what they're doing, what their skills are on social media. Or your marketing team or the HR team is putting job postings that are saying, hey, we need engineers who know how to use a certain technology. Now, if that technology is open sourced, you may get a letter from Intellectual Ventures saying, well, you probably are infringing our patents because you're hiring engineers who are using that technology. So my suggestion for companies in that situation, when you're using AI, whether you're an HR person, whether you're a marketing person, whether you're a financial executive, minimize discussions of open source technology in public situations. Instead of saying, I want to use something like a Kafka engine or Kubernetes engine, say something generic. It's some kind of a virtualization technology. And in the interview, you can raise it about a specific skill. But if something is open sourced, you're potentially asking for letters from all these companies that map their patents to these open source situations. Now, the community alliance is important because there are organizations that are aware of this. It's called OIN, Open Innovation Network. They are started, I believe, by Red Hat, Toyota, Microsoft, and I forgot the fourth one. And now a lot of banks and insurance companies have joined them together. And the idea is basically that everybody cross-licenses their own patents to every member of their organization. And the idea is that a lot of these patent assertion entities acquire patents from companies that just want to divest and make some money on the patents that they're not using. So the idea would be, if the patent originally was owned by one of these companies, it won't be asserted against the member against it later. I think the membership in OIN is free. I suggest it to a lot of people. I think that the pros outweigh the cons. But the idea here is, in order to minimize the stuff, especially what's been going on over the last 2 years with these open source lawsuits and letters, this is something to be mindful of. Now moving over to Bob.
Amazing. Thanks, Roman. So as you can probably already tell, we bring different things to the table here. Roman's the smart guy, like I'm the guy in the blazer. I'm going to be talking about generative AI. So that's what I bring to the table in terms of how I advise clients in the situations where they're interfacing with AI, a particular type of AI, which is AI that's being used to create what we would traditionally refer to as creative expression or expressive material. The challenge in Canada, and I'm going to be talking mostly about copyright, is that we don't have any legislation which is responsive to AI in respect of copyright, and we have no court decisions yet. So giving advice can be a challenge here. What I want to try and do is give you some frameworks or some heuristics which can assist in trying to assess the risks and how you should respond to these challenges. We're going to start with this. When we're talking about generative AI, we're basically talking about inputs and outputs. So every AI model ingests a bunch of content. You then, the user, interact with that content or interact with that model in some way, usually by prompting it, telling it, I want, make me a picture of a clown. And then it generates an output. And usually you do something with that. So creative expression, we're talking about things like images, film clips, music, scripts, dialogue, emails. Anything that's written or recorded, essentially, is at least in theory potentially protectable by copyright. When we talk on that input side, the potential risks there, if you're developing a model, most of the generative AI models scrape an enormous amount of content from the internet, right? They need lots and lots of data to analyze and to map and to make predictions. That's almost certainly copyright infringement, right? What we do know from Canadian case law and copyright is that simply reproducing something or copying it amounts to copyright infringement. There may be applicable defenses to that infringement, but we'll assess that in a moment. So at the first stage of the process, the ingestion, almost certainly copyright infringement. You as a user, if you're using those models, if you're asking it to generate output which you're going to use, the thing you need to be most worried about is there a potential for vicarious liability because the output too strongly resembles or too exactly reproduces an input. Somebody has created something, it's been ingested into an AI model, you input a prompt, it generates an output which matches that thing which was protected by copyright in the first place. As I said, when it comes to copyright in Canada, we don't have a ton of guidance from legislation from the courts, and so that puts an enormous amount of pressure on contracts. So when you're using these models, you have to do a close assessment of the terms of service which all of them use. The questions we're going to explore in the next few minutes are, what kinds of rights are you giving to the AI model, to the service provider, when you input content, when you input prompts? What kind of rights are you giving them under their terms of service to your content? And what kinds of rights are they going to have over the stuff that you generate, over the outputs that you generate? Right, so if you have employees who are inputting, as was flagged earlier today in our keynote speech, if you have employees who are inputting screenplays, which haven't been seen before, if they're inputting internal emails which have confidential information or trade secrets, what can that model do? What can that service provider do with those inputs? And if they are generating content which they are then going to use, what can the model provider do with that content? So I want to flag something here. The biggest risk is, as I mentioned, that new content infringes old content. So your output infringes an input. But there's a lurking risk here, which I think a lot of people, particularly those who don't spend a lot of time thinking about or interacting with copyright, miss. And I think I want to underscore this for your attention. Under Canadian copyright law, you need a human author to create copyright-protected material. There has to be a human. If you don't have a human author, you don't have a work which is capable of being protected by copyright. What we're seeing in the United States, with the limited number of decisions that we've seen there, some guidance from their Copyright Office, content output created by a model, an AI model, has no author and therefore is not protected by copyright. The challenge for you is, if you are using a model to create an output which is not protected by copyright, it means you can use it, but it also means anybody else can use it. If that output is not protected by copyright, and somebody takes it and uses it, you have no claim against them, at least not a copyright infringement claim. So, as an example, which we've encountered on the entertainment side, we have clients who are using generative AI models to create character designs, right? The output is a new character. They want to use that character. It's going to be the lead character in their new animated series. If somebody else takes that character, takes the design of that character generated by that AI model, they don't have a claim against them, or at least not a copyright infringement claim. So as I mentioned, that puts an enormous amount of pressure onto the terms of service analysis and the kinds of risks that are posed by the contracts that are imposed on you or that you agree to when you use these generative AI models. You have to read these things really carefully. I'm sure many of you are doing this already, but for those of you who aren't, I want you to be aware of what kinds of risks lurk in these terms. Most of these generative AI models are provided on an as-is basis, right? In other words, the service provider is not standing behind those models, either their inputs or their outputs in any way. They make no representations or warranties. They're telling you explicitly, you may get content which we are also delivering to other people. We're telling you it may generate inaccurate, incomplete, offensive content. The risk is on you, the burden is on you. You have to have the procedures internally to make sure that you aren't using that content in a way which exposes you to liability. In terms of liability, often these services are provided on an as-is, whereas basis in the sense that they make no representations or warranties about the content, they provide no indemnification for the content, or if they do provide any indemnification, their liability is often limited to the value that you have provided to them for the license fee. In fact, in many cases, as we will see, you are granting the service provider rights. So you are giving them the right to use your inputs. So again, when you put in images, when you put in screenplays, when you put in emails, they then have the right to use that content as they see fit often, in many cases. So I want to give you this model to think about how you would protect yourselves, how you would modify your workflows and modify the policies and procedures that you have in place. So there's three things. You want to protect yourself against their problems, you want to protect yourself from them using your stuff, and you want to ensure that you own your stuff. So protecting against their problems. As I said, lots of liability inherent in the scraping which is going on. Lots of content which is ingested. All that's copyright infringement. Make sure you are getting indemnities. Make sure you're getting representations and warranties where they are at least willing to stand behind their own business model, that they are working with licensed material, and that they are willing to provide you a rep that says, if our content, if our output infringes, we will indemnify you for any losses that you suffer. Also really critical to make sure that there are constraints on their ability to use your stuff. Sometimes that's accomplished operationally, right? Making sure that your data is in a walled garden, so the only person or the only entities that can interact with your data are you and your employees. Sometimes you want that to go an additional step so that they delete their data, your data, sorry, within a certain period of time or automatically upon your cessation of the use of the service. You want contractual covenants on their part, which is that they won't make your data available to anybody else. The only way they can use your data is in the provision of the service to you. And then in terms of making sure that you own your stuff, we want to make sure that they disclaim any ownership, right? In the sense that they say, hey, if there are any intellectual property rights here in these outputs, we don't own it, and we transfer it to you as the user. I was asked to speak about fair dealing in Canada. As I said, we don't have any decisions yet from courts which consider copyright infringement in Canada. There have been a couple of lawsuits, 4 lawsuits filed in Canada, large ones, which address the infringement in the ingestion of large volumes of content. We suspect, we haven't seen the statements of defense, but we suspect that one of the primary arguments by the defense is going to be what we are doing constitutes fair dealing. Fair dealing is a defense to copyright infringement. Fair dealing is complicated. I certainly would not want to make any predictions about whether the fair dealing defense is going to be successful, but I did want to give you a hint as to what that defense would look, or what that argument at least would look like. So in Canada, in order to get a fair dealing finding, you have to have an allowable purpose, satisfy applicable statutory criteria, just ignore that for our purposes today, and the dealing has to be fair. There's only 8 allowable purposes under the Canadian Copyright Act, and those are listed on the slide. So research, private study, criticism, review, news reporting, education, satire, or parody. So the people that are being sued for copyright infringement have to make the argument that their generative AI model, that their service, can be slotted into one of those 8 allowable purposes. And the courts have said, look, we interpret these purposes broadly, but there are limits to what these words mean. So can any of these generative AI services plausibly argue that their services slot themselves within one of those allowable purposes? Let's say they can, right? Maybe they can argue, well, our users are using our model to create content for research purposes, or they're using it to make humorous content which is going to constitute satire or parody. They then have to slot themselves, or they have to satisfy a 6-factor test which assesses whether the use is fair. As I said, I think this is going to be a tough argument for these defendants to make, that this constitutes fair dealing. So there's potentially an enormous amount of liability floating around out there. We are almost at time in terms of having to, or getting a chance to answer your questions. What I did want to end on was these survey results. I want to start at the top there. So who should own the outputs created by generative AI models? 29% said that those outputs should be jointly owned, jointly shared between the creators, so the owners of the AI models, the service providers, and the users. So if I use a generative AI model to create a character design or a screenplay, 29% of people said, oh, it should be the generative AI model owners and the users who use it. I want to submit to you that that is madness. That is absolutely the wrong answer. Joint ownership of intellectual property is a recipe for disputes. It's a recipe for uncertainty. It's a recipe, that's great for lawyers, right? Lawyers love that. But in terms of running a business, in terms of being able to value pieces of intellectual property, that's going to be a real nightmare. I think the only 2 plausible answers that we should be advocating for, and as I said, we don't have any legislation yet, so we may be looking at having some kind of legislative intervention here. The only 2 plausible answers here are the user should own it, or that nobody should own it. Right? Those are the only ones which give us any real certainty in this space, which is rife with uncertainty, both with respect to things like authorship, ownership, potential liability, potential defenses in the face of infringement claims. So we are at time. Are there any questions that we can answer from the audience? Yes, sir.
that book and you input it into ChatGPT. And ChatGPT's terms of service say, hey, if you input stuff in here, now I own it. But I never authorized you to input that into ChatGPT. I mean, what happens to my copyright claim on that?
Look, for all of, I think the revolutionary potential of this technology, in some ways, you know, it is relatively conventional, or at least it's easily analogizable to existing technologies. So your claim, if somebody takes your song and uploads it to YouTube without your permission, your claim, your copyright ownership is not modified in any way. Your claim is just as sort of viable as it was before the infringement. I don't think the answer is any different with respect to a generative AI model. So just the mere fact that somebody has ingested it or uploaded your content to the model doesn't affect your ownership. You still have the viable claim. I think the challenge, almost like the YouTube situation, is how are you going to identify who uploaded it? Right? There's a practical evidentiary challenge there, but at least at the level of the theory and the analysis of the ownership and the claims, nothing really changes. Mr. Baskin at the back.
I can appreciate that the results of the survey say that those who make or commission the material produced by when they're the generalized AI should be the owner. The downside of that is it's the almost complete disempowerment and discouragement for the creator. Most creators don't have the resources to generate the product, distribute the product, and so on. And as we've seen in American proceedings, in contracts, usually the company that organizes the show owns all the assets. And it's very, very difficult for the individual creator to put his shovel in the ground and own anything when this is over. Do you think the policy issues we're going to have to deal with, either in the courts or in the legislatures, should take the rights of the individual creator into account, or is that story over?
I think the challenges presented in this context are very similar to the challenges that we've seen unfold over the last 25, 30 years with digital technology and the internet more broadly, in the sense that we've seen the technology, you know, as it disintermediates, it shifts the balance of power to the infringer in a lot of cases. It's very difficult to enforce your copyrights in, you know, a digital environment. I don't think we've successfully met that challenge more broadly. I think potential solutions involve things like collective licensing, so a more EU-style approach where the government intervenes to ensure that value is transferred from users to owners, potentially through some kind of collective society mechanism. But it's a real challenge. I mean, as we heard earlier, we're currently in a situation where we're dealing with a new mechanism for delivery, still dealing with old content that's getting pushed through the pipe. We've been dealing with that same challenge for the last 30 years. I don't think we've risen to it yet. We haven't solved that. I don't know that generative AI really alters the calculus all that much, but I do think there needs to be a legislative intervention. Oh, sorry. Yeah, uh-oh. Yes.
So if I think about the previous talk where they were defining AI and showing us some of those definitions, pretty inarguably some of those definitions would include anything typed on a touchscreen keyboard or with a spell checker, right? So, but now we're hearing that if it's generated by AI, it can't be copyrighted. But if I'm having an ongoing interaction with the content, at what point does authorship get reintroduced? Like, or does the AI just being there contaminate it forever?
Yeah, I'll just make a brief initial response, and then I'll throw it to Roman to see if he wants to add anything. I'm not convinced that we shouldn't just be thinking about these generative AI services as tools, right? So in the same way that, like, if I use Microsoft Word to write a novel, like I still own the copyright in the novel, right? Microsoft doesn't suddenly own the words that I produce. The question is, how complicated are the words that I've produced? If I type in one word to Microsoft, one word, I don't have copyright in the word. If I type a poem or a novel, it's certainly protected by copyright. I think there's some odd US decisions or Copyright Office positions which have said, look, essentially, no matter how much or how involved your use of the generative AI model is, no matter how many prompts you enter, no matter how often you iterate or how many times you iterate, it's just simply not protected by copyright. That sort of seems like the wrong decision to me at the end of the day, right? Like if I enter an initial prompt and then I iterate on that prompt 400 times, like at some point there, it seems to me that that should be output, which is protected by copyright. We don't have an answer to that at the moment, in Canada at least. I don't know, do you have a view on how the US is handling that?
Well, I know that there was a policy recently, policy paper issued by US Copyright Office on AI, and I think it took some positions that were not politically approved. And I know the US Register of Copyrights was terminated. Now, what the positions, whether those positions are actually applicable or not, I don't know. It's going to take some time. But in terms of, on the patent front, I think what you also raise is an interesting scenario, is there was a case a couple of years ago on who owns the inventions that are people generating with AI. Even can AI be named as an inventor? So right now, almost all the courts worldwide said no. The inventor is the owner of the system, or maybe the person who prompted it. But this is something that's it's going to develop over time. Generally, I think that was a very outlier case. In my experience, most inventions that involve AI are not AI invented, but I do see, prompting the AI to prompt something to help me invent. Those could be interesting situations. Because sometimes the inventions, people typically think of an invention being a technical solution to a technical problem. But sometimes the invention is the recognition of the problem to begin with. If you realize that, and the solution may be obvious. So maybe sometimes in recognizing the problem is what's the inventorship, is what makes the invention unique. I think Sarah Blakely, was the famous example of that when she came out with Spanx. The solution is obvious, but no one ever thought of the problem in a certain way. So it's an open question, I think.
Yes, sir. Table 11.
I think there's a few fallacies going on. There's parallels as well. So if you look at the patent world, and then we'll come back to the copyright world, in the 60s and 70s till 1982, software was not patentable until the Supreme Court allowed the Benson case, the use of algorithms and mathematics not to preclude the patentability of software. And so it became a situation where we had to frame the software as controlling hardware. In copyright, the fallacy of what I'm hearing fundamentally is if you look at art, computer-generated art in the 60s, which was mostly mathematics, algorithms, transformations, metamorphosis, those were all copyrightable. Yeah. So the fact that you used a plotter or a screen to display something that was generated through an algorithm did not preclude copyright. So it's not up to the Copyright Office to decide what's copyrightable or not. It's a pendulum that swings, and it takes a 10, 15-year cycle to go from one extreme to another for something to be, quote, copyrightable or patentable subject matter, which is a court decision, not a copyright USPTO decision.
Right.
Therefore, the notion of generative AI is a parallel to generative art in the copyright field and authorship. So I would suggest that if the generative is 100% by a machine, one could argue that a human's not involved. But as soon as you involve a human interacting to do the generation or to instruct the generation, that's where the copyright law should swing at the court level, allowing generative AI, just like generative patents are copyright-based, action is legitimately patentable and copyrightable. So I think there's a whole fallacy in saying that generative AI is not copyrightable, because otherwise you couldn't have a book generated, which you sell on Amazon, and protect it, because anybody else would have the right to say it was generated by, quote, AI. And that's not a valid argument for the whole world to use and infringe on the copyright for the authorship. So I think it's just one big fallacy. It's not a Copyright Office decision, it's a Supreme Court decision. Thanks.
No, thank you. So I'll finish with this observation. So historically, I think often the way that Canadian IP policy has been made is to rely on court decisions. And we make policy the same way throughout all kinds of different legal domains, right? We expect parties to sue one another, the courts make decisions, there's a result. That's a great solution if the courts are functional and it doesn't take you 5 years to get a final decision, right? If we could get court decisions like in a few months, especially at the pace of change that we're seeing with this technology, fantastic. We cannot do that, right? The courts simply take too long for a variety of reasons, some good, some bad. I think my message would be we need legislative intervention. That's why I was so heartened to see, our minister speaking. We need the certainty. It's a really bad idea to leave it to like a bunch of guys like me sitting there going like, well, on the one hand, we should do this, and on the other hand, we should do that. Like, we need a decision at the legislative level so that maybe it's the right decision, maybe it's the wrong decision, but at least we have some certainty as to what the result or the policy is. I'll finish there. Hello.
I just want to add to what Bob was saying. In terms of the patent stuff, I do want to say that the current US Secretary of Commerce, I forgot his name. He is the named inventor on like 400 patents. He's very pro-patent. He's given a bunch of talks and conversations about, Howard Lutnick, that's his name. He's given a bunch of presentations and speeches that are very pro-patent. And right now I know there's a bunch of, there's two big patent legislations in Congress in the US. One is called PARA, Patent Eligibility Restoration Act, which will make patenting AI simpler and easier. And the other one is called Prevail. It's about getting injunctive relief right the minute you sue. It's presumed, and it's not something you have to actually prove. So while on the copyright stuff, I agree with Bob that there's given what's going on in the US and in Canada politically, there's time for, time will dictate as to what the copyright policy is, but on the patent front, I'm bullish on the United States. I mean, right now, all the signals and signs are pointing to a pro-patent environment, given the geopolitical competition with China, and given the fact that Howard Lutnick is he's a big inventor, he owns a lot of patents, and he's pushing for that to be monetizable and being able to be used as a tool in US policies.
Okay, thank you. I've got a question from online for Bob. When it comes to both terms of use that you mentioned, as well as determining ownership, which might be dealt with contractually, it can be very difficult to negotiate those terms. There's really, is there any scope to negotiate those terms with providers of AI, or really even get in touch with them? I mean, OpenAI might not be ready to return your calls to negotiate their terms of service. So how practically do you deal with this?
It's a great question. I mean, I'll make an observation from the film and television space. So you may be familiar with the concept of stock providers. So providers of stock footage, stock images. So people like, the really big companies are like Getty, right? So you have the Gettys of the world who have millions of images. They have websites. You can license a particular photo from them. There's also like, getfreephotosonline.com, where they give you like images under certain terms of service. When you're doing commercial grade film and television work, really none of those licenses work well. But what we have found is that the reputable providers like Getty, you can go to them and ask for specific bespoke terms for an industry, for film and television. So you can get what's called a film and TV rider. And that's in response to market demand, right? It's in response to an industry saying, we need different terms because otherwise this service just doesn't work for us. And so I think we're going to see a similar kind of organic response, market-driven, in response to concerns about liability, about ownership. So it's going to take time, unfortunately, but it's the same sort of dialogue between a provider and a seller, and that's what will distinguish, I think, reputable providers from disreputable ones, for lack of a better term.
Okay, thanks, Bob. And one here for Roman. Anthropic published a research paper on April 3rd entitled "Reasoning Models Don't Always Say What They Think." If they conclude that chain of thought models may omit or fabricate reasoning steps, and actually they rarely admit that they have omitted or fabricated reasoning steps, even if they're challenged. So in less than 2% of cases, the model will fess up, right, and give you an accurate picture of the chain of thought. How many grains of salt should we be taking with chain of thought LLMs?
It's a good question. In general, I'm a patent person, but in general, I take these models very conservatively. Just because it tells you, it doesn't mean it's true. It hallucinates a lot. There's no right or wrong answer here, but my suggestion is, at least to minimize what these situations of making stuff up, is to rely on tools that employ RAG. RAG stands for Retrieval Augmented Generation. It's a technology that minimizes hallucinations to the extent possible. And what it does is, when you submit your query, it augments and supplements your query with its own proprietary information. And when the result comes back, you're getting a better answer because your prompt is limited by your knowledge and your own information. But given that this proprietary source that they employ, and it comes back with sources and expanding in your own augmentation, so the likelihood of that being hallucinated is going to be lower than a conventional Copilot or ChatGPT input. The common tool that people use for this is called Perplexity. I think it's good, but everyone has their own preference.
Yeah, but if it's not good, we don't know. So, okay, so I'm going to keep Bob and Roman up here for one more minute. So as we break for lunch, we invite you to stay and enjoy a special immersive experience right here in this space. A bit of history, picking up on our art theme, is at this venue now. The Design Exchange was originally the Toronto Stock Exchange and operating here from 1937 to 1978. The murals on the back wall that you see are painted by Charles Comfort, and they reflect the industries that powered Canada for nearly a century ago: agriculture, manufacturing, transportation, and construction. Today, this space tells a different story, one of technology, creativity, and innovation, with spotlight on the tools of the future, including AI. So during lunch, take in the visual journey around you, which will include breathtaking natural landscapes, a futuristic reimagining of Toronto, out-of-galaxy environments, a serene sequence where rain will fall across the room, and even a trip under the sea immersing you in deep ocean visuals. So most of what you are going to see today is AI generated. So it offers a glimpse into how AI is reshaping the world of art and storytelling. So enjoy your meal, enjoy the experience, and take a moment to appreciate how this historic space in Toronto continues to evolve. We will be back at 12:45 for the rest of our program. Thanks very much, and a special thank you to Bob and Roman.
See, only you have that magic technique. When we sway, I go weak. I can hear the sound of violins long before it begins. Make me thrill as only you know how.